Hello, everyone, and welcome to Trusts Talk with Mark Bennett and Adam Hofri. With us today, we are very pleased to have Richard Grasby. Richard is an offshore regulatory trusts and private wealth lawyer. He's also a partner with Appleby in Hong Kong. Richard, welcome. It is a great pleasure to have you as our guest on our podcast.
Pleasure to be here. Thank you so much.
So, to start with, could you maybe just tell our viewers and listeners what you do for work? What does the work of an offshore regulatory trusts and private wealth lawyer consist of?
Well, yes, you may well ask. Our firm is, as you say, categorized as an offshore law firm. That means effectively that we practice the laws of so-called offshore jurisdictions. In fact, Appleby practices the laws of 8. We don't do Hong Kong law, even though we're a Hong Kong law firm. We're in Hong Kong to provide access to our legal services for the local market and have been there for over 30 years. The Hong Kong office mostly focuses on Cayman Islands law, BVI law, because of the regional usage, but also we do some Bermuda, Jersey, Guernsey, and other laws. I look after, as you say, the private client trusts and regulatory team. Most of my work is trust law. Most of that would be private client focused, but it does have some unit trust work, some orphan structure work, some charitable trust work. And occasionally there are creative uses of trusts for commercial purposes, which we always like. But the day-to-day work would be for private clients. The rest of the private client practice is wills, probate, estate administration, other such matters. We're increasingly looking at private trust companies, and comparing the jurisdictions, looking at how they're set up. Occasionally, we look at full licenses for institutional companies looking to set up in Cayman, BVI, etc. Although that's relatively uncommon if you look at the number of licenses over the years. And then for the regulatory practice, that's, I would say, relatively new for the offshore firms since CRS, FATCA, global transparency. The offshore jurisdictions have had to join in international initiatives, or in fact lead international initiatives, you would say, things like beneficial ownership, economic substance, anti-money laundering and the like. So I advise on that, and that's a hot topic, particularly with the overseas territories and access to beneficial ownership information.
Just to follow up, I think it's fascinating. You said that you don't actually practice Hong Kong law as a firm. Is that right?
Correct. We're not allowed to. We're a foreign law firm. So I'm a registered foreign lawyer. And one of the restrictions on that actually is we can't practice Hong Kong law. So actually most of our work would come from Hong Kong law firms or international law firms looking for offshore advice in the same time zone, often in other languages such as Mandarin, Cantonese, written Chinese, etc., in the time zone as well. So the offshore law firms from some jurisdictions, not all, there are huge advantages of the bigger jurisdictions, Cayman, BVI, Jersey, Guernsey, you can have access to information in virtually any time zone. Bahamas, you can't. Bahamas is a great jurisdiction, but actually there are only Bahamas law firms really in the Bahamas. So you can find 10, 15 Cayman law firms in Hong Kong, 10 in Singapore, a number in Dubai, a number in London, and so none of them are practicing the local law. And if we did start practicing English law or Hong Kong law or Singapore law, we would lose our attractiveness to the firms there. It would be a commercially naive strategy to take. So there aren't many offshore firms that also do onshore work. It tends to be some of the litigation firms. There are a number of examples, but most of the offshore firms stick to offshore. The movement in some cases has been to go to complementary sort of funds jurisdictions. So a number of the offshore firms do practice in Ireland and Luxembourg, for example. We don't, but a number of our competitors do. But again, that's not seen as such a big competitive disadvantage compared to doing English law or New York law or Hong Kong law for global transactions. So we're in Hong Kong, but we are effectively not a Hong Kong firm at all. Although, because I've been here so long, I get a lot of queries about Hong Kong matters. So people say, Richard, he's in Hong Kong. I'll ask him about Hong Kong Trust or Hong Kong Will, and I have to pass that on to friends and colleagues in the market.
Yeah, so Listening to your description of what you do, one is interested in your career path. I mean, how did you get to be a prominent offshore trusts lawyer? What was your career path like that brought you to this point?
Yes, it is somewhat unusual, I'll agree. I took a job as a trainee lawyer in the late 90s in Jersey in an English law firm. Now, that arrangement is very uncommon these days, and even then it was. So straight from day one, I was in an offshore jurisdiction, dealing with offshore structures, but in an English law firm, dealing mostly with UK-related tax structures. I did that for 3 years, 3.5 years. Then I moved to London to a tax and trusts firm. Again, a slightly unusual firm because SJ Berwin was sort of pioneering the private equity market. We were doing a lot of carried interest trusts for UK-based fund managers, relying heavily on the as then non-dom tax rules, which were very favorable for that kind of trust arrangement. After that, the opportunity came to go to Cayman. The first merger between a Jersey Guernsey firm and a Cayman firm had arisen in about 2004. So I joined OGA's Cayman office in 2005, stayed there, did a full range of Cayman work. So funds, trusts, companies, etc. And then the opportunity came to join the biggest Cayman firm in Hong Kong as a trust lawyer and to be the first trust lawyer to be located in an Asian office of the offshore firm. So that was 2009. And I've been here ever since. I've since moved a couple of times and ended up back at another leading offshore firm, Appleby. But the move was to carry on doing Cayman work, adding BVI, because Asia is BVI's main jurisdiction. So adding BVI from 2008 onwards, and then coming to Hong Kong in 2009 to carry on doing Cayman law. And my job actually mainly was then focused on looking after the unit trust practice, which was a much higher percentage of the fund structures in Asia were Cayman unit trusts. The Japanese market love Cayman unit trusts. That's probably a separate podcast. But also the private wealth, which is increasingly using Cayman since the mid-90s. BVI has always been used by Asian-based clients, particularly Chinese, Hong Kong. And since moving to Appleby, we've got Bermuda capabilities, Channel Islands capabilities, and occasionally we have Mauritius as well, because we're the only offshore firm in Seychelles and Mauritius.
Great. So just to make clear to the uninitiated, in using the laws of all these different offshore jurisdictions, there are no licensing requirements, right? I mean, you can use the laws of wherever without having to go through some licensing hoops put up by the different jurisdictions.
You mean for the law firm?
Yes, or for the individual lawyers.
That's definitely another podcast. Cayman has just brought in rules for effectively overseas practicing certificates. So we will be bringing that in during the first half of this year, because historically that was linked to having a work permit being based in Cayman. Now you will be able to effectively have practicing certificates for non-residents. BV, I'm on the role as an attorney through being an affiliate of a BVI office, our BVI office. So that's linked to me personally. Those are the main jurisdictions we practice. A number of our lawyers in Hong Kong are registered in Bermuda. We have a Jersey lawyer, but local, there are strict rules, which I think Isle of Man has restrictions on us practicing outside of the Isle of Man, but we don't really do any Isle of Man work at all from Hong Kong. We would send those queries direct to the other offices. The vast majority of work in the Hong Kong, and now we've got Shanghai and Shenzhen offices, are Cayman BVI. And those are effectively governed to a certain degree because we have a mothership in Cayman and BVI, and also we can be registered with the jurisdictions.
So just to follow up on that, because it's fascinating for someone who focuses on the law of one legal system at a time, basically, in my own work, to think about how you go global, you go international and using these different jurisdictions. But in terms of what the structure looks like, where are the assets? Because do the assets need to be held in these offshore jurisdictions, or may they be somewhere else?
No, I mean, you're right. The assets are ultimately not in most of the jurisdictions from which we practice. The people, definitely from the Hong Kong office client base, are not in those jurisdictions. Obviously, our Cayman office, Jersey office, etc., has local clients. The institutions, the trust companies are often there, but as we shall come on to later, are not always there. But in the Hong Kong office, the clients, the movers and shakers, the human beings are not located in the jurisdiction. And ultimately, the assets are not. The main asset in BVI, for example, is BVI companies, but BVI companies own assets anywhere in the world, with a few exceptions. So indirectly, the ultimate asset is well, arguably never in BVI, particularly for the Hong Kong office client base. And there's no requirement that, say with a couple of exceptions, that for trust structures, that there's any nexus to that jurisdiction. A choice of law of a trust will be recognized in most cases by international conventions and by the local trust law, even if there's no other obvious connection to that jurisdiction. Yes, if you've got statutory structures like Star Trusts, Vista Trusts, where they are only created because of the local law, there has to be some form of connection to the jurisdiction, but that's actually not universal either. So where you have a Jersey law purpose trust, you actually don't need a Jersey trustee at all. So for a BVI Cayman special trust, you do need one of the trustees to have some link to those places. But absent anything else, you can have a offshore trust in most cases.
Great. So moving on from the structures in your career to the client base. I mean, what can you tell us about the types of people that currently settle international trusts? Who are these folks and why are they doing so? What would be the major reasons or situations pushing them to make use of these structures?
I think there's no one-size-fits-all type scenario. There's no particular dominant market in the sense of where Jersey and Guernsey used to have a very UK-centric market because of the tax system until maybe the mid-2000s. The Hong Kong market is dominated to a large degree by mainland China because we're in China, but that's not the total client base. We have clients from Taiwan, Singapore, Malaysia, Philippines, etc. So I would say we have an Asian focus in the Hong Kong office for obvious reasons. We have a China dominance for obvious reasons as well, by virtue of size, economics, location, etc. Why do people want to set up trusts? Each person has slightly different motives. Tax is less of a driver than it is in historic UK, Canada, US structuring. Many jurisdictions, none of the big jurisdictions has a state duty any longer. It was abolished in Hong Kong 2006, abolished in Singapore similar time. China's never had it, although there are rumors. India abolished state duty, and there's rumors that it was going to be brought back. Japan and Taiwan have a state duty, but again, they're not massive markets. So tax is a factor, but it's not a dominant factor. Most of the factors would be things like confidentiality, avoiding probate. So assets on a death, there's no change of ownership, so there's no probate, which is both time consuming, disruptive, and a certain element is public. Providing for the future generations, but not having to make absolute gifts. I think that would be the main driver, a sort of warehousing of assets for future generations without actually having to make a gift to someone. So you can make provisions for people who aren't born yet. You can make provisions for people without having to give them all the money now. Keeping assets in a block holding. So particularly for the family companies, if you have 60% of the company, there's generally an increased valuation. If you had 3 lots of 20% for your children, then there's less aggregate value and there's more potential disruption to those trustees. And all of a sudden, the company's got lots of small shareholders and actually the family power is less. So you get that. There is some tax deferral. And then you get the sort of loosely called asset protection, but it's not the asset protection that you may see marketed from certain jurisdictions on a creditor type basis. It's more of safety, security, and perhaps we'll come on to this later, just having assets looked after in a structure that's perhaps in a more stable jurisdiction or more stably looked after. So they call it asset protection, but it's not asset protection in the sort of immediate creditor challenge type scenarios that you might see from certain jurisdictions, but it is a factor, particularly from emerging markets or even frontier markets. People are liking to put assets in a structure that's seen as safer, and that would be what they would regard as asset protection. It could be political risk, political change, government seizure, all kinds of things. It's not the same as unscrupulous business people trying to set up structures which may has a certain connotation in certainly the old asset protection trust type marketing.
I've looked at Cook Islands trusts, which are very much marketed as offshore asset protection trusts. Very difficult for creditors to access the assets within them. And obviously that has spread onshore to America, the domestic asset protection trusts. And there's a real trend for states to put their own kind of Cook Island style asset protection trust in place, which is quite fascinating. But you're saying that that's sort of a different ethos or a different function for the kinds of offshore trusts that you're looking at.
Yeah, I mean, people are interested in how offshore judgments can be, overseas judgments can apply in our jurisdictions, the what ifs, what can someone do, how could someone challenge it, what are the weaknesses of the structure. But I wouldn't say it's real creditors in the sense of some of the, well, Cook Islands has good legislation. Historically, there's been occasional allegations of misuse, and then certain jurisdictions, certain states of the US similarly have perhaps been marketing structures for, the so-called negligent dentists and things where they're concerned about their own personal assets. That, for some of our clients, I'm sure they are concerned about keeping assets out of their name, but certainly Cayman and BVI are not segregation type jurisdictions. Cayman's whole secured structured finance industry is based on being very creditor friendly. So actually, there's a 6-year period, and whilst it's maybe tighter than say the UK, it's still 6 years as opposed to 2 years in the Bahamas, perhaps, and sort of instant in some jurisdictions, sort of dry ink type scenario. There are obviously other factors at stake, like where are the assets themselves? And as we've said, they're not always in the offshore jurisdictions, at least 100%. So if you can freeze bank accounts in New York, or you can go after land in Malaysia, then it doesn't really matter what your structure is to a certain degree. But Cayman is not marketing itself as a asset protection safe from existing creditors. What they would say is we'll have structures that are safe from challenges, but certainly a real challenge would have grounds for being successful because the jurisdictions are not there to facilitate legitimate claims. Now, what legitimate claims are is open for debate, but certainly the so-called negligent dentist is not really the business that most offshore jurisdictions want, particularly if the trust was set up after the botched operation or whatever. That would not be something that we would be wanting to promote. But with clients from certain markets, it's never clear what quite they have in mind as what they're being protected from. Certainly, if you've got controlling governments, which is a large portion of the world, that is a potential, well, not creditor, but a potential threat. And that's the sort of security that people are looking at. Now, as we shall come on to, I'm sure, in later questions, where are the people? Where are the ultimate assets? If you own a coal mine and it's owned by an offshore structure, come and take the coal mine. I mean, the Venezuelans took the oil platforms. I mean, they doesn't matter how they're owned, although it may be beneficial if there's investment treaties and things like that, because I think in certain jurisdictions like Singapore, but Barbados, in those scenarios, Mauritius would have a better option than, say, BVI or Cayman, because they do have investment treaties if you can find the time and the assets to win. But that's a slightly different type of structure where you're looking at more immovable type, infrastructure type assets like land, mines, farms, oil platforms, as opposed to bank accounts, gold portfolios.
Yeah, I mean, from a New Zealand perspective, what you're saying about the kinds of offshore structures and purposes that you're dealing with, it seems very close to what we do domestically in New Zealand with our family trusts, which serve all those purposes of asset protection, marital property or relationship property, preventing claims from that area is quite prominent in New Zealand, succession planning as well. We obviously benefit from having a reasonably stable government and a trusted legal system. So we get all those things onshore, and it's quite interesting how much the middle class, and not just the high net wealth individuals or the most ultra rich, are using New Zealand family trusts. So our next question is, the kind of trust structures you're setting up, they seem, from what you say, to be targeted or accessible to the high net wealth individual, and not so much a middle class option. Would that be correct?
I would say yes. There's no prohibition. You've just got to look at some of the economics. If you're looking at a professional, taking proper professional advice from people who are international in their focus, then there's a certain amount of costs to that. If you want a high street firm from Hong Kong, the hourly rates will be a lot lower than the big international firms. So, if I'm doing a trust for a local client, there's going to be a disparity in the level of fees, even if it is a competitive market. In our respect, you do need to have a certain level of wealth to make it worth doing. If you're looking at professional trustees, which again would be the market that in the main we would be looking at, or a proper private trust company, the sort of DIY trusts, yes, you can do them, but in some respects they wouldn't be the best structures that we would be offering, because individuals as trustees are themselves prone to the risks that most of the trusts are designed to try and avoid, like death, incapacity, moving jurisdictions, etc., losing capacity. You're looking at a trust company. Most trust companies these days, particularly, the ones with ambitious private equity owners, they're not doing it for free. So there's a minimum level of wealth that you would need to justify having those kinds of structures. There's no minimum amount for a trust. So we get asked, can we have $1 million in a trust? That's a lot of money. I'm not saying $1 million is not a lot, but in the scheme of some of the structures, to pay $10,000, $20,000 a year for a trustee and $20,000 to set up a structure, then that $1 million doesn't really make that much sense unless you think it's going to be 10 million. So it could be a seed amount, a nominal amount, a sort of base level, but at some point it's probably got to be a certain level of wealth to make sense. If you're doing mom and pop trusts for your family home in New Zealand, there's no fee really, is there? That you're not paying trustee fees. You're probably using a fairly standard structure from a local New Zealand law firm, and so it doesn't really matter what the level of wealth. So we can do trusts for any value. It's just that it tends to be of a certain level. And yes, wealth is relative. Most of the institutions would take 30 million US liquid as the ultra high net worth, but you could do a trust for a lot less than that. When you start looking at international structures, it tends to be several million of some value. So therefore, on a global census, that's probably not middle class. Middle class would be 1 to 5, let's say, in many jurisdictions. We could do trusts for that. Trusts for insurance are a lot lower than that, but they're more of a fill in the blanks product and don't really necessarily have the costs for the advisory level.
Is there a culture for more middle class people with a bit of wealth who own a small apartment perhaps in Hong Kong? Is there a culture like there is in New Zealand, or even in quite a lot of countries where the trust is a bit more native, or it's been there for hundreds and hundreds of years? Do you see people taking advantage of that without the offshore aspect?
There are. There's Hong Kong trusts being set up all the time. Hong Kong's got a long established trust law. It ticks most of the boxes. It was updated in 2013. You can have perpetual trusts. You can have settlor reserved investment power. The trustees are sort of regulated to a relatively light touch, but they're still regulated. So the costs may be lower for a local trust company here. If you don't want some of the bells and whistles of offshore laws, which we'll come on to, then you could use a Hong Kong trust. But equally, as we're seeing Hong Kong trustees of foreign law trusts, that's been a long established trend. Likewise, Singapore trustees of foreign law trusts for reasons that we'll come on to from a geopolitical and convenience type perspective. The Chinese, obviously, mainland China is a different market entirely. If you take it to its absolute, you've only really had private ownership of assets for the last sort of 30-something years. So let alone offshore investments really only started in the last 20 years, I would say. And then Chinese trust law has been developing and is now seen as being able to be used for succession planning, whereas initially it wasn't. And during COVID, and particularly with more difficulty in getting assets out of China, then advisors that I work with have been looking at more domestic structures, so more PRC trusts for PRC assets. There was only cash, I think, originally allowed to go into PRC trusts. That may have evolved over time. Hong Kong obviously is a completely different market. Hong Kong is very property centric, as I'm sure you're aware. Stamp duty can be a big problem, particularly with the increased stamp duty that we saw to cool markets in various jurisdictions. So putting assets into a trust is easier said than done. And so UK clients, Hong Kong clients, one of the biggest impediments is putting land into trust because you have an immediate stamp duty charge, unless it's a nominee, which doesn't really work. So you can't say there's no change of beneficial ownership or any of those old exclusions that used to be around. It's now an immediate charge, which can be, double digits of percent. And so, whereas on a probate, a will trust or a distribution from probate, there's no stamp duty, is my understanding. So a lot of clients would rather wait for a will or a probate to move land than put it in a lifetime trust. Of course, if you've got properties held through companies, particularly BVI companies, then those are freely transferable, so those can go into trust structures and often are. Yeah, so I'm not conscious as to the number of Hong Kong trusts. Certainly, most of the trust companies I deal with are more international, so they will have some, but often it will be a minority of their portfolio in Hong Kong. They'll either be the administrator where the trustee is in another jurisdiction, or they will be the trustee, but the governing law will often be Cayman, BVI, Jersey, etc.
So, we were wondering, what trusts questions do you see litigated most often? And what do these disputes tell us about how trusts are actually working in practice versus how they are designed to work?
Yeah, it's a wide range of potential challenges or real challenges. If you look at the law reports from the various jurisdictions, which obviously we all do, you'll see quite a lot of applications for blessings. So, in some cases, the judge has been quite critical of why the trustee is even there in the first place. But effectively, you've got certain events have happened or certain tax changes have happened where we're into sort of momentous decision-making territory. So we've had quite a lot of applications to the court. But most of those are non-contentious. But occasionally we've got a few where they are contentious, which is quite interesting. But I would say the sort of public trustee and Cooper blessings applications are quite prevalent in the offshore world at the moment. Jersey seems to have more than most. Bermuda has a few. Cayman's had some, etc., etc. So that's what we're seeing. But there is a range of scenarios where those come to pass. We have seen quite a few attempts to do what I call the sort of statutory mulligan, because you didn't take into account a relevant factor or you took into account an irrelevant factor, etc., etc. So you basically pretend that it never happened type scenario, which is always quite interesting. But you do see those once or twice a year in most of the jurisdictions. Usually that's basically a screw up by someone, it seems, or a misunderstanding or whatever, but effectively it is quite a common option to look at. Generally, capacity now is probably the bigger one that we're seeing, not in terms of volume, but there's a few cases out there for mental capacity in terms of decision making. So what is the relevant level of mental capacity for a power holder particularly? And that will increase because people are getting older and therefore the risk of perceived or actual mental impairment is higher. Litigation is generally higher, particularly from emerging markets. The appetite for litigation is probably more than it was. People even threatening litigation so they can get a settlement, whether they actually really intend to go through with it. Yes, there are costs, risks, but even threatening litigation these days can be a tactic that people use without actually going ahead and doing it. So capacity will be there and continue to be there, I think. And then also older trusts, as you mentioned, trusts that were set up 70s, 80s, 90s, mostly, I would say the 90s. The family circumstances have changed a lot since then. The definition of children, parents are same-sex marriage, those sort of things. There are lots of older trusts that don't necessarily apply to the current scenarios, so therefore people tend to want to go to court for direction, I would say. That those, seeing a few of those on the case. Divorces are increasing in most jurisdictions. The biggest challenge to trusts for jurisdictions without tax is probably seen as some sort of divorce challenge. People talk about the 50%. It's not strictly true, but effectively the starting point still in the UK, Hong Kong, etc., is 50-50, and then we adjust from there. So it could easily be 30 something, and that's a big chunk of assets. I think divorce challenges are prevalent, or divorce planning. Whether they go to court or not is a different matter. As Adam knows, I think there should be some more challenges on the basis of marital property, in the sense that did the spouse whose name the property was in own it? Was the settlement trust itself valid, which would apply to certain jurisdictions? We haven't seen many challenges on that, but I think that could be one that we see. So those would be the ones. I mean, things like access to information has been around for the ages, but whether those actually go to court or not tends to not be the case. But it can get semi-contentious in the sense that sort of correspondence and things.
And I was just asking, are you seeing a trend of people using arbitration for trusts matters rather than litigation?
Well, it is a hot topic. So I know New Zealand has it in your law. Guernsey has an abbreviated arbitration provision. Bahamas is probably the one that we see the most of. It certainly comes up a lot. Jurisdictions are looking at it. The issue has always been to make it binding on people who were not party to the deed, not that you really have parties to the deed, or certainly not even around, or not capable of consenting, those sorts of things. But certainly a desire to have alternative dispute resolution for confidentiality and sometimes cost reasons, although some lawyers would disagree that it is actually that much cheaper, but is a factor. We're not seeing it so much in our jurisdictions yet. Cayman, particularly Jersey, are quite good, if that's the right word, on giving anonymized jurisdictions and having hearings in private, particularly where there's minors and things involved, whereas other jurisdictions, I think New Zealand is open justice type jurisdictions where you can sort of toddle on and watch any court application in many cases. So even the Privy Council is doing a Bermuda Trust case at the moment, and that's all anonymized because the video wasn't available because it was minor beneficiaries and things. So is there an immediate need for ADR where you've got the established trust court principles that can be enacted? Maybe, maybe not. Certainly from a contractual perspective, a lot of the Chinese clients want their disputes dealt with in Hong Kong in Chinese. So we will see a move for that, which may extend to private client structures. But that's a convenient cost basis as well as a sort of perceived time saving and cost. I mean, some courts are jammed up for years, so actually ADR is essential. Other courts, you can sometimes get urgent hearing dates in matters of weeks.
The mention just then, Richard, of marital property and challenges and sort of a starting point of 50-50 distribution post-divorce separation. I mean, we have a very similar thing in New Zealand, 50-50 presumption or starting point. And importantly, relationship property is initially, the first thing you look at is what's the property acquired during the relationship, the fruits of the relationship, except for the family home. If there's a family home, that's within the relationship property pool, and then so 50-50 is the starting point. And many New Zealand family trusts are set up to prevent that happening, prevent the house that the couple is living in from falling into the relationship property pool, because it's not owned by one of the relationship partners, it's owned in a highly discretionary trust. So that's the context in New Zealand that I'm always focusing on, and we've got a number of challenges where there were a number of reserved powers that the settlor retained, also roles that they retained, either as trustee or as protector, and the argument was, well, that trust is ineffective to avoid the 50-50 sharing. The house, which is owned by the trust, really should be seen as the property of the settlor, usually. Now, my understanding of English or Hong Kong marital property law is They don't have a property standard, which is quite a formalistic idea of what is your property, but a financial resources standard, which allows you to say, even though this isn't a trust, you've got those powers, that role, this relationship with the trustee, for example. They're just going to do what you say. If you ask for a distribution, we just think that's going to happen. It's more likely than not to happen, and therefore we'll count that as your financial resource. Those are the kind of things that I'm thinking about when I'm thinking about marital property challenges. What's your take on those ideas?
Yes, but obviously the lawyer's caveat that we don't advise on Hong Kong or English law at all, let alone matrimonial asset division. And as we've said earlier, the ultimate clients tend to not be in our jurisdictions, the structures are. But certainly the courts make an order on financial resources. There's been the likelihood test. What is the likelihood that the trustee would distribute the trust fund to the husband? Usually, if we think the answer is yes, then we're going to put that in the pool of resources that are in the marital pot, irrespective of who owns them. So they're not saying the trust is invalid. They're not saying that the trustee doesn't own the assets. They're not saying there's no trust. They're just saying that the resources include the assets in the trust or a certain portion of them. Now, that is separate from reserve powers to a certain degree, because the discretionary trusts, a lot of them are discretionary trusts, arguing that they have no interest in the trust. They have a hope value. It's not an asset of theirs. It's not available to creditors. But then we look further than that and say, but what is the likelihood that the trustee would listen to your wishes, or often called requests? But wishes would be the traditional view. Trustees, as we've always said, don't do themselves any favors by referring to people as clients, by referring to requests from clients, by referring to how quickly they agreed to said requests from client, and aren't they good? But actually, that's your discretionary trust model. If you're into the sort of reserve powers trusts, illusory trusts, your web and web type trusts, that's a different argument. Again, is there actually a discretionary trust at all? So you don't even have to go through those arguments. You're still the beneficial owner. You can have as many devices and structures and documents and words as you like, but when the music stops, it's still yours. Now, that they haven't said there's no trust, which is a slightly strange scenario. There's some form of not bare trust, effectively, because the trustee still owns the asset. I suppose that would be the ultimate one. Although I think in Web and Web there wasn't even a separate trustee. In Pugachev there was a private trust company with his sort of New Zealand lawyer as one of the directors of the PTC, etc., etc. So you sort of see, well, what's the result that they want? If you have a normal reserve powers trust with a professional trustee, then you should never be anywhere near sham territory. You should almost never be near illusory trust territory, but you could still have weaknesses because of the number of powers that the settlor has retained. So there's a sort of third level of structure. If you have PTCs or self trusteeships, then you're into a much higher risk. If you're into professional trustees with lots of reserve powers, you're still in a certain level of risk, but I say that risk can probably be managed. Although, as we're now seeing, that irrespective of whether the assets are at risk, the tax consequences also become more prevalent because you're deemed to control or you're deemed to own them. So that's a whole different world as well. So you've effectively got no trust at all. You're deemed to have an interest in it. You're treated as having an interest in it, even though you don't. There's different levels. And I think that the danger is not one of the law, if the structure is set up properly, it's interpretation from other jurisdictions or how it's run in practice. So, as I mentioned, if the pattern is you made 4 requests to the trustee and the trustee paid you each time within 3 hours and no one else is allowed to make any requests and no one else received anything, it's not a huge leap to say that you have some sort of stickiness to that structure over and above other people. The one divorce lawyer I was speaking to said, look, you basically don't want them to think the trust is your ATM, because that's going to be the argument that they run to. If you need cash and all you do is ask the trustee and they pay you, then it's a very easy argument to run. If the trustee says, no, go away, if the trustee pays other people, it may be a little bit artificial, but at least if the trustee turns you down, if the trustee says, no, you had some last time, or the trustee says, no, we need this money for something else, and the documents and evidence show that, that is a much better argument than to say, every time you asked, you got it. No one else was allowed to ask. No one else got anything. It's not a huge leap to say that's a resource of yours. I mean, and that's the danger from a divorce perspective. So, setting up trusts needs to be looked at, and then it needs to be looked at how it's administered in practice. And certainly trustees can also help that by how decisions are documented, how correspondence is recorded, how letters of wishes are structured.
This is what I find so fascinating, is this interplay. The whole idea of a trust is, if you're the settlor, you no longer own the property. There's a very prominent phrase, I've seen many practitioners refer to it as well: have your cake and eat it too. And it seems to me that, especially once you start talking about the reserved powers and being a protector or being even a trustee, which we see those things very much in New Zealand, there's that dance of we're setting up the structure in New Zealand or in an offshore jurisdiction, but we've also always got to have our eye to what the onshore jurisdiction of the settlor might say from a marital property perspective. And within the structure of the trust, when you're advising, the settlor, what is advisable? How much of the cake can you have and eat? It feels like that's a really delicate balance. And I've seen commentary around Asian settlors not having so much of a culture of trust, particularly, I guess, mainland China, and really the lawyer seems to have to work to make sure that they understand things have changed. You can't have your cake and eat it too. You should have less control than you would like to have. Is that something you're having an eye to in the way when you're setting up trusts?
Yeah, I mean, that's been a shift. It's not Chinese trait, but most wealthy entrepreneurs from certain jurisdictions are used to being in control. Therefore, giving assets to a stranger and paying them and having been told to have no control is a completely foreign concept and makes no sense. So actually, in some respects, you bring in a protector who's your person, but actually protectors aren't supposed to protect the settlor, they're supposed to protect the beneficiaries. So that's antithesis as well. So being told that you can retain powers is a selling point, otherwise you'd never get the thing over the line. Now, a lot of clients in Asia particularly would never want discretionary investment management services. So they want to manage it themselves. You speak to the banks, the discretionary mandates are much lower than other people. People want to do it themselves. They want access to structures and products and service lines. They don't want access to expertise. But during a downturn or recession, generally the professionals lost less than the individuals. They always make less because they've got to be more conservative. When you start looking at other things, can I change my mind and revoke the trust? Yes. A lot of the trusts that we set up for the US, that are all revocable. But from a UK tax perspective, I never did any revocable trusts because they just didn't work for inheritance tax, right? Now, a revocable trust, there is still a trust. I mean, that's but it's only a trust until the nanosecond before the power is exercised. If you can change a trustee, then you control the trust for the IRS, let's say, and you control the trust for CRS. But actually, in my mind, you don't control the trust at all. You have the ability to change the trustee, but you don't have the ability to control the day-to-day operations of the trust. But it's seen as a sort of threat. Going back to our position about litigation challenges, I think there should be more challenges about people being removed as trustee, because that is a fiduciary power in most jurisdictions, irrespective of who has it. And I think trustees are removed for all kinds of reasons. And some of them should say, I'm not going, or court should give me directions about whether I've been removed properly. But anyway, that's a side point. So I think this cake and eat it is there. Now, what we're seeing now is the increased transparency. Now, that's sort of tail wagging dog in the sense that people's behavior is changing because the chances of being caught is increased, not because the rules have particularly changed. I'm about to generalize, but without generalizing, the mentality is often what's the risk of being caught rather than what does the rules actually say. And so if there's more speed cameras, people will drive slowly, but not because the speed limit is there. They will drive slowly because they think they're going to get caught more. So CRS has shifted quite a lot of behaviors in the sense that people now know about your structure. And China has been getting the data since 2018. There's now been some questions saying, well, tell us about your offshore assets, tell us about your offshore structures, because this lovely piece of Excel spreadsheet has come from Singapore or come from Jersey or come from Cayman with your name on it and a nice number of your account, but we don't know anything about this. So why don't you tell us about this? Now, if you were not a controlling person, now you may still be the settlor, but if you weren't a controlling person, then that bit wouldn't happen. So we saw a massive pushback on being protector if you were from the PRC, because most jurisdictions for protectors with real powers would report them as controlling persons, and the entire trust fund is in their notional account, even though as a matter of trust law, as protector, you have no interest in the trust fund really as a proprietary interest. But certainly protectors with no real power, dilution of protector powers or bringing in protectors from Hong Kong or other places is a big trend. Now we're seeing, because of that, people saying, well, I don't want to have all these powers, or maybe I should have professional power holders, professional protectors, professional trustees as well. But there's still a danger of people trying to go back to sort of nominee protector type scenarios where they'll put someone their cousin in Hong Kong on the trust deed, but they're really doing what they're told. You know, Russian cellists and things. I mean, you could have all kinds of scenarios where you're going back retrogressing in terms of compliance, because you're actually putting people as office holders who aren't really the power holder, which doesn't help. But I think having too much power is seen as a red flag and can bring tax consults. Now, management and control of companies is fairly widespread across the world in terms of if companies are managed and controlled from a certain jurisdiction, they can be tax resident there. Trusts are obviously a whole different concept. So we've had that one case in Canada, I think, where the trust was controlled, tax resident in Canada, but hasn't yet got to China. Now, they don't have trusts, but they don't have trust entities, but they have enterprises that are taxable, and it wouldn't be a huge leap to sort of say, well, all the activities here, you're making all the decisions, let's tax it, but we're not quite at that stage yet. We haven't, as far as I'm aware, we haven't had any, big examples of, say, BVI companies being taxed in China because they're controlled from China, but it wouldn't be a huge leap.
So as a final question, I mean, listening to you, one gets the impression that the offshore model, the offshore enterprise is alive and kicking. So will it be correct, in your view, to say that the onshore campaign against offshore financial centers that seemed fairly serious at certain points in time, that campaign is now essentially over, or that it has failed, or that it has run its course in CRS coming into being and the US equivalent FATCA, and in offshore financial activities becoming more transparent in that sense?
No, I think the challenges remain. Jurisdictions are short of revenue. Jurisdictions are aware that perhaps their citizens aren't as fully compliant as they might be, and that in some respects offshore is the problem. Offshore may be part of the problem, but it certainly is not the entire problem. You've now seen global minimum tax, where just because there's no tax in Cayman, profits from Cayman activities can be taxed somewhere else as a sort of method of hoovering up profits from other jurisdictions. That's less of an issue for private client structures, but it is a direction of travel. You've got the whole arguments about whether there's a level playing field or not, which still remains in terms of what standards the offshore jurisdictions are held to compared to the onshore jurisdictions, and that just ever increases. You see the US basically abolishing beneficial ownership registers, except for a few exceptions, deferring AML rules in the first place. Their lawyers aren't subject to AML. Australia, I don't think lawyers are subject to AML yet. China. So to compare the regulation in our jurisdictions to much of the onshore jurisdictions is chalk and cheese in terms of the level of activity. You've got, unique to some of our jurisdictions, you've got the role of the United Kingdom with regards to the overseas territories, the constitutional arrangements. So the desire/threat to have public registers of beneficial ownership, whether they're legal or not, whether those jurisdictions want them or not, is still there. Yes, the legitimate interest test has come in. in Cayman and soon BVI, but that is noticeably more than any other of our competitor jurisdictions. So you could always argue that Cayman is, from a confidentiality perspective, at a disadvantage, even though there's a sort of restriction on the information that's available. Whether the UK regime itself is compliant with international law is an interesting question. I'm surprised that no one's actually challenged the UK PSC register. The UK think that it is. The expectation of the UK government is that the overseas territories and the Crown dependencies will have a public register sooner rather than later. But I'm not convinced that that's the case. And certainly other jurisdictions like Bahamas, Singapore, Hong Kong, Switzerland will not. The US not. So you can't say it's a global standard at all. Exchange control, big jurisdictions that we deal with, India, China, Vietnam, have capital controls that are being more enforced, I would say. And the reality is, particularly with CRS, is how has money got out of these jurisdictions? Not the tax necessarily, it's the compliance. So you're now getting issues about onboarding times, onboarding abilities. We've seen the use of a whole myriad of structures and devices in scams, and offshore tends to get the brunt of that, even though banking is generally not purely offshore. People are certainly not purely offshore. Crypto, you could argue, is not an offshore creation, although it does help as part of these perceived scams and things like that. Offshore tends to get the brunt of the pushback. But I don't think it's the end, because people are far more global. People live in lots of different jurisdictions. People invest in lots of different jurisdictions. People move around lots of different jurisdictions. And you couldn't just pick a base in a traditional onshore jurisdiction, because actually there's lots of moving parts, whereas most of the offshore jurisdictions, there's an element of stability and certainty, irrespective of what happens at other levels of the structure. Occasionally there's jurisdictions with blacklists, occasionally there's prohibitive taxation because a certain jurisdiction is used, but in the main, it's a fairly neutral structure and point to have, irrespective of circumstances change. Whereas if you go all in onshore and then move somewhere, there's less flexibility. So I think there's still an essential part of using the structures that we advise on. The laws, to a certain degree, don't get affected by taxation. So if you look at trust decisions from Australia or Canada or the UK, there's usually some sort of tax issue as well as trust law. Whereas in Jersey, Cayman, Bermuda, it's much more about the trust law rather than trust law as part of tax enforcement. So I think there's still a place for that.
It's just wonderful to hear all these fascinating insights. What I think it's revealed to me is the richness and complexity of offshore trusts. And also, everything's ongoing. We had, how long ago was it? The Panama Papers caused this global...
10 years ago.
Yeah, this global scandal. But we've obviously got the results of that in some of the enhanced information sharing regime. But there's all sorts of things happening now with technology, geopolitics, which, are going to change the next year. It could be completely different the next 5 years, 10 years. What do you think are going to be the key considerations, the key factors that settlors and their people helping settlors set up trusts, what are they going to be thinking about, and how's that going to change or keep things the same in terms of the kind of structures that you're setting up? Are we in for turbulence and change, or do you think that the fundamental way that offshore trusts work is going to just continue because it's a proven structure?
Well, it's hard to predict exactly, but certainly we need to be able to adapt and have flexible structures. We need to have structures that can stand up to threats that are as yet unknown or as yet haven't happened. So we are seeing, certainly at the higher end of the client base, diversification of structures, diversification of jurisdiction, diversification of service providers who, as I said earlier, we have quite a lot of interest in quote unquote leading trust laws like Jersey or Cayman, but actually, do you want your trustee in a jurisdiction that's controlled to a certain degree from the UK, certainly for foreign affairs, sanctions, etc. That's a London decision. So I have a Singapore trustee, but I have a Cayman law trust. my trustee is in Singapore. That's an independent jurisdiction. It's been very passive on sanctions against Russia. It's been very neutral on other things, Western trust law. It's got judges, law firms, etc. But it's not a UK territory. Maybe there's a play for having my trustee in that jurisdiction, but equally, I could have a trustee in another jurisdiction. We see potentially having trustees now in Switzerland. Now, Switzerland doesn't have its own trust law, but has spent a lot of time and effort developing and regulating its trust industry. There's over 120 licensees now, I think, in Switzerland, lots of people, lots of infrastructure. And it's Western. Yes, it did elect into the EU sanctions against Russia and Belarus, but it's certainly more benign perhaps than the West in the sense of the US, UK. It's said that it will never forfeit assets, whereas other jurisdictions, the jury's still out. And the advantage of, say, Switzerland is the assets are also there. So your trustee is where your bank is, which you could never say about certain jurisdictions. So again, you could have the same trust, but you could have one with a trustee in Cayman, one with a trustee in Switzerland, and one with a trustee in Singapore. They're the same trust, but you've sort of hedged a little bit in terms of where your trustees are. How are assets held? I mentioned investment treaties. The standard off-the-shelf company for certain assets may not be the way forward because those could be appropriated. Action by, I think, Saudi against the Swiss bonds because of investment treaties. The world is sort of developing in the sense of what might happen to your assets and what might you need to do about it. So multiple structures, different jurisdictions, different service providers in the sense that, well, that trust company might be sold, that trust company might be hacked, that trust company might blah, blah, blah. We even see people wanting trustees who are only in one jurisdiction. So they don't want the office in X to be hacked, but then access to the whole global network. So we do see, who's only got an office in Cayman. And then the other thing will be setting up your own structures for peace of mind as to who's got access to what are you reporting. But that is a different level of investment and structure. So these sort of cheap and cheerful DIY structures are probably on the way out. But likewise, a lot of people would be interested in doing things themselves because they don't trust the information that's being held by third parties, and they don't know what's being told about them to all and sundry in their mind. A lot of banks have a reputation for reporting everything, whether it's technically reportable or not, just because it's easier and in their mind safer. Whereas actually, if you're responsible for your own reporting, you're responsible for your own data privacy, then it's on your head. So, I've seen family offices with their own trust companies where, everyone's got certain phones, everyone's on certain emails, everyone's got restrictions. And so they are trying to lock down potential cyber security threats because it's in their hands, in their mind, it's in their hands, not in the hands of a jurisdiction far away in a trustee company that they know nothing about. Planning, people are looking at different residencies, different citizenships. But again, I think there's going to be pushback on that. I think that we are not far off having mandatory red flags on certain jurisdictions. St. Kitts and Vanuatu, unfortunately, do crop up a lot in some of these scandals. And I think that just because of how the compliance world works, risk-based is going to start making almost prescriptions about what high risk, in the same way that they do about high risk jurisdictions. You could say it's not fair. I think they're going to start making those sorts of determinations on people who are claiming citizenship or residence in certain jurisdictions. CRS already mandates it, but I think AML has done a paper. But I think we're at this stage where certain jurisdictions will be higher risk. There's already a perception that if you're mainland Chinese, you're being red flagged in Singapore because of what's gone on there. People then looking at other beneficiaries, other settlors. You go full circle back to the bad old days where people will pretend that it's someone else just because of how compliance is going. So it's not free from challenge, but flexible. So you need structures that can adapt, that can move, that can change, not locked in. And that will be the message.
And in all of that, you're needing to go to an advisor with deep expertise, knowledge, and that strategic insights that you've so well demonstrated there, Richard. And I know that you're very active on LinkedIn, so people who want to keep up with these developments, and you're also so kind as to share some of your insights in your posts, which are extremely useful for someone on the outside looking in, trying to understand these structures. So I would definitely recommend following Richard on LinkedIn. Is there anywhere else you'd suggest people follow or get in touch with you?
You can subscribe on our website. We also have a WeChat account, but LinkedIn is probably the best place to start.
Great. I'll just say in conclusion that this entire scene and practice is so fascinating that I'm just curious as to why we don't have half of legal academia pouring into this field, looking at offshore trusts and similar practice, but we really don't, right? I mean, this is still a niche area in academia. And so we are trying, by way of this podcast, to create something of a wider exposure among both practitioners, academics, and the curious public to this sort of practice and this field. And you have done us a great service, Richard, and not just us, but our listeners and viewers too. And so thank you very much.